In advance of preparing an exclusive right to sell agreement, you should have obtained a tax and legal description of the property from a title company and verified that the person or entity entering into the agreement has the authority to dispose of the asset. This would include a trust, LLC, or estate. Individuals who have these types of situations are prepared to supply you with the documentation as to their authority, and they will also have to provide this information to the title company at closing. In addition, we require that even if a property is only deeded in one individual's name, you must acquire both signatures from both spouses if they are married, regardless of when the marriage took place as it relates to the purchase of the property. If the parties selling the home are married, both signatures are required. If the parties are divorcing and absent a court document that states otherwise, both parties are your clients and both must sign all documents. The first section, property. Fill in the full address, including any unit numbers or multiple address numbers. Include the permanent parcel number, which can be obtained from the tax and legal. Exclusive right to sell. This paragraph must be completed with the end date of the agreement as well as the commission rate. Our rate is 7%. You should never write a lower commission in the document suggesting to the seller that our commission is less than 7%. Should you need to negotiate, you are permitted to do so as outlined in the P&G manual. If you are charging an additional commission, previously known as an administrative fee, then do so on the first line prior to entering the commission amount and percentage. Note that this additional commission is subject to company dollar until you are capped. The following paragraph is fairly straightforward and tells the seller what their obligations are. Under this agreement, they cannot sell the property to anyone else by owner. They also cannot sell the property to anyone who viewed the home during the marketing period for 6 months after the home has been taken off the market, unless it is listed by another broker. This is in sharp contrast to Howard Hanna's listing agreement, which obligates a seller to a commission regardless as to whether or not they list with another broker after the marketing period. This potentially obligates the owner to pay 2 commissions. Use this as a selling point when competing against Howard Hanna. Cooperation. This states that we reserve the right to choose who we will cooperate with and who we will offer compensation to as a co-broke. It also states that we reserve the right to determine the amount of the buyer-broker compensation. Authorization to market. This states that we are able to promote and syndicate the photos and video of the property. It also permits us to place a sign or a lockbox. In the case of some communities or condo developments, lockboxes or signs may not be permitted. If this is the case, inquire with the HOA or condo association for clarification. Fair housing. This paragraph puts the homeowner on notice as to their obligation to comply to federal fair housing laws. Disclosure. This requires that the seller disclose all defects that are known about the property, as well as the lead-based paint disclosure form. They are also required to disclose if they have been notified by the sheriff's department that a sex offender lives nearby. They must let us know if any legal actions are pending against them that would affect their ability to convey clear title. In the event of foreclosure, short sale, estate, divorce, or bankruptcy, it pays to ask questions before you market the property due to the fact that in some rare cases, it would mean the home cannot be sold. Page 2. This informs them that they're also put on notice that we cannot assist them in filling out the Ohio Residential Property Disclosure Form. Confidentiality. This states that we will keep all matters confidential, and in addition, the seller agrees to provide notice if there is anything additional that they wish to be kept confidential. Excluded fixtures. This is where the seller writes what will not remain with the property other than their personal effects. If none, be sure to write the word none. Home warranty. Seller may elect to have a home warranty. If this is the case, you must indicate who the warranty provider is and the cost to be paid at closing. You must also provide a home warranty acceptance or waiver form with the listing packet. Inspections. If there are inspections required by the municipality where the property is located, this paragraph notifies the seller that it is their obligation to order the inspections, pay for them, and deposit the findings into escrow prior to title transfer. Property maintenance. This states that we are under no obligation to maintain the property for them, and they are advised to winterize the property in colder months. Usually we suggest October through April. This is also a good time to discuss with them the importance of keeping the home secure and obtaining vacancy coverage on the home in the event that they will be moving out. Binding agreement. This states that this agreement is a legal binding document and we are only to provide marketing services only. The seller agrees to retain other professionals as needed. Finally, your client signs and completes the section that asks for all of their contact information. Remember, if they are representing an entity or have a POA, they must sign as indicated in their legal documents on behalf of the entity or POA. If they are married, both parties must sign. Finally, you need to sign the bottom of the form as their agent on behalf of the broker.